Welcome to Policy on Demand. I'm Nita Asher. I'm pleased to be joined today by Nils' cousin to talk about the U.S.-Taiwan tax proposal. Nils, welcome.
Thanks for having me.
Would you remind us what's in the proposal, what benefits would be conferred to Taiwan, and are there any contingencies?
Yeah, so basically this is a legislative proposal that would enact Section 894 Cap A, which is a statutory provision, and it would provide treaty-like benefits to residents of Taiwan. So it wouldn't be a bilateral tax treaty, but the idea is that through this statutory mechanism and enactment, we would end up with something similar. So there are a couple of main benefits. There are reduced U.S. withholding taxes for dividends, interest, and royalties that are paid from the U.S. to residents of Taiwan. There are some provisions that would apply the treaty permanent establishment standard rather than the domestic law effectively connected income standard, which would make business profits of Taiwanese enterprises from activities in the U.S. somewhat less likely to be subject to U.S. tax. And there are also some favorable provisions that would permit Taiwanese resident individuals that are in the U.S. Providing services to not be subject to U.S. tax with respect to their income from those services. In terms of contingencies, a big one is that similar to income tax treaties that the U.S. has, there are very strict limitation on benefits provisions that are designed to make sure that it's not just any resident of Taiwan can get these benefits and access these benefits, but that there are certain requirements that would really test whether like a Taiwanese company has a bona fide connection with Taiwan, for example, being publicly traded on a Taiwan stock exchange, something along those lines.
It's very helpful, Nils. What are your thoughts on the proposal's references to the 2016 Model Treaty?
So a little background on that, right? I already referred to these limitation on benefits provisions. The U.S. has had a long history, really since the early 80s, of having these objective limitation on benefits provisions in its income tax treaties. Over time, we've had model treaties, 1996, 2006, and then in 2016, and each time that we have, that the U.S. Treasury has put out a new model treaty, which is sort of generally serves as the baseline from which we start negotiations, we have made the limitation on benefits provisions stricter and stricter and stricter. And in the 2016 model, I don't know, I think what was in the 06 model, maybe it was 6-7 pages of language, and suddenly it became a 20-page or something like that limitation on benefits provision. So it's much stricter. Although that's now the treaty policy. The U.S. hasn't actually entered into, there's not any treaty in force right now that's based on that strict 2016 model. And the Treasury never put out a comprehensive technical explanation to that 2016 model. We've signed one treaty to date, which is the treaty between the U.S. and Croatia that is based on that 2016 model. But again, that hasn't entered into force yet. It hasn't been ratified yet. And so here in this statutory proposed language, the limitation on benefits provisions, to the extent that there are specifics in there, they are very much based on that very restrictive 2016 model. And then there's also statutory language that says, look, of course, Treasury and the IRS are going to be issuing regs if this is enacted, and there's a grant of authority, but there's this expression in the statute that any regulations that they would issue under this Section 894 Cap A would be consistent with and based on the 2016 Model Treaty. Now that's interesting, I think, for a couple of reasons. Number one, it certainly seems that the drafters of the statutory language are supportive of the strict and tighter 2016 model. But given that we don't have a technical explanation, if this were to be enacted and then Treasury will embark on the regulatory process of issuing regulations that are going to apply to this Taiwan agreement, that might then be something that in future treaties that would be based on the 2016 model, that regulatory language, while not strictly speaking on point, I think would be very relevant in terms of how that might be interpreted going forward.
It's very helpful. What hurdles remain in getting the legislation enacted?
Well, it's got to get passed, right? And who knows what happens with tax legislation. I think generally in Congress and from the administration, there's pretty good support for this. but it's part of broader tax packages. I don't think anyone is trying to move this as a standalone thing. So whether this gets passed or not, and when it gets passed or not, is really, I think, just whether tax legislation in general gets passed. And there are people, of course, probably on other policy on demand things that people can watch that know a lot more about that and about the legislative process than me. But my understanding is the further you get into an election year, the longer this might take. But if I were to handicap it, I would never handicap when it might get passed, whether it would be this year. But my guess would be that at some point, unless there's a major sort of shift in policy towards Taiwan, at some point I'd be optimistic that it would get passed.
The bipartisan interest, but also your point about reciprocal benefits, having Treasury needing to certify that Taiwan is providing reciprocal benefits. So from a timing perspective, there's still a ways to go, potentially. Yep. Well, thank you, Nils, very much for being here. And thank you for joining us on Policy on Demand.